Hernandez case. If we can go ahead and, Mr. Said, if you could announce the case name and the cause number.
We're here on Gustavo Hernandez and Francisca Freya Gonzalez versus Lacey Gibraltar, DC 2006452. Joey Said appearing for plaintiffs Hernandez and Gonzalez.
Okay, let's go ahead and get started.
We have.
I'm sorry, if we could have the other parties also make an announcement.
Oh, yeah.
Yes, Your Honor. Catherine Schneider representing Lacey Gibraltar, the defendant.
We had a couple people just join the room, Mr. and Mrs. Time. What are you here for, Mr. Time?
Hello, Your Honor. I have a hearing at 10 o'clock. I was just joining to make sure that I could get into the Zoom session.
Okay, great. All right, you may proceed.
Thank you, Your Honor. We're here on a no evidence motion for summary judgment on a couple of affirmative defenses. By defendant's response, I believe sudden emergency has been conceded and they will amend their answer, so we will not have to talk about that today. But I'd like to start with comparative negligence. Defendant brings up two points of evidence to try to support their defense that the plaintiffs were comparatively at fault. And number one is the fact that the plaintiff did not have a driver's license and did not go to driving school. There is no claim for negligent entrustment. And as you know, whether somebody holds a driver's license or not does not speak on whether they're acting as an ordinarily prudent driver in their situation. It only goes to the minimum competency. Driving in Texas, you can even drive with a foreign license and you'll be okay. That bit of support that the defense has raised is irrelevant and does not support comparative negligence. The second point defense brings up is that now this was a situation where traffic was beginning to slow down, and the second point of evidence that they bring is that the plaintiffs began to slow down and stop for traffic. There's no evidence in the record that they, in fact, rear-ended anybody else prior to being rear-ended by the defendant. What defendant is essentially arguing is that by exercising prudence, they are, in fact, negligent. They were stopping for traffic. That cannot amount to negligence, and that is only a scintilla. Even when you indulge every inference in favor of the defendant, you can only infer that the plaintiffs were slowing down to avoid colliding with the vehicle in front of them. Of course, the evidence on the record, the defendant herself admits that she cannot testify to anything that my clients did that were at fault. And she even admits on the record that she should have kept a longer distance for stopping, and that she knew that, traffic tends to stop. And there's a reason why the plaintiffs were able to stop in time, is because they were exercising prudence. With respect to failure to mitigate damages.
Let's kind of go through these one at a time.
Okay.
So the response, I agree with you. The failure to have a driver's license is not a basis for negligence. There's extensive case law on that. But on the other point, what is your argument, defense counsel?
Yes, Your Honor. When we took depositions of both the plaintiffs and the defendant, Ms. Gibraltar, it's pretty undisputed that the stop was sudden. And even the plaintiff stated he had to stop suddenly, and then he was suddenly hit from behind. So I believe we are arguing that the fact that he had to stop suddenly could be argued a mere scintilla of comparative negligence. of if he stopped suddenly, even if he was able to avoid a collision, it still could be argued due to his sudden stop caused the sudden rear ending by my client, Mr.
I agree
Belcher.
on that. I mean, I guess to the extent that, I don't know if you can break this up, but if there's, I'm going to deny it as to the summary judgment for the sudden stop, but I will grant it for, but I really don't know that it's just one claim for negligence. It's not two different. I mean, what I would suggest the best way to deal with this is just limiting out the driver's license. And so, and then for the other claim, I guess I'm going to deny it. So what's the next one? Fail to mitigate.
Failure to mitigate damages. Well, the defendant needs to show that plaintiff's decision not to mitigate caused further damages. And
I looked at that. I'm going to grant that. I don't.
Okay. And the only thing that they're saying is that
I just granted it.
oh, you granted for failure to mitigate. I'm sorry, Judge. I didn't hear you.
That's okay.
So we're going down from comparative, failure to mitigate, sudden emergency, and then now we're at unavoidable accident. The element where defendant's claim or defense fails on unavoidable accident is that it must be a non-human condition. And
Granted.
Okay. I suppose, Your Honor, there's that's all we have.
All right, just give me an order. So granting as the failure to mitigate and an avoidable accident, and denying it as to a comparative.
All right, Your Honor. Thank you very much.
All right, just give me an order on that. Email that to my court coordinator as well as e-filing them.
All right, thank you.
And try to do it by preferably some point today if you can.
Okay.
All right, thank you.
Thank you, Judge.
Okay, it's a little bit early, but we're here on the Angels Word versus Watson case. Are both sides here already, or I see Mr. Henley's here. Is your opposing counsel here? You're
I don't think that he is just yet. And by the way, it's Angel Sword.
Angel's Sword. Oh, okay. Not Angel's Word. Okay.
Right,
That's right.
No,
it's a sword manufacturer, isn't it?
That's
They
right.
make it for the Renaissance Fair and Scarborough Fair and stuff like that. I didn't know those companies. I guess they
Existed?
would have. Well, I knew they exist. I knew people made swords. I guess I just never thought about them having companies, but I guess they would have to have companies. So it's interesting. Miss Watson, is your attorney here yet, or is Mr. Henley your attorney?
Yes, Mr. Henley is my attorney.
Okay. And then let me see. We have sometimes kind of hard to tell. Well, let me have my interns go ahead and introduce themselves to Mr. Henley while we're waiting for his opposing counsel. Why don't you start, Megan?
Hi, my name is Megan Simmons. I'm a 2L at SMU.
fantastic. Have you enjoyed your first year?
I did. I enjoyed it. It was good.
Well, I actually have a 2L in my office from SMU watching all of this. So she's learning just as you are.
What's her name?
Her name is Morgan Maker.
You know her, Megan?
Morgan Maker.
I don't. I hope she's not in my section. I'm sorry. I am really bad at names.
Well, that just means that she's not one of those annoying gunners who's always raising her hand and annoying
Exactly. She won't know my name either, for that record.
Ashley, why don't you introduce yourself? Oh, you're not? Okay. Dominique?
Hi, my name is Dominique Lee, and I'm a 2L at Texas A&M.
Fantastic. So what's the most interesting thing that you learned in your first year, Dominique? And you
Probably
too, Megan.
the rules against perpetuities. I watched like so many YouTube videos trying to teach my rap.
Well, guess what?
Something you will probably never use.
That was exactly what I was going to say. What about you, Megan?
I'm sorry, could you repeat the question?
What's been the most memorable or interesting thing that you've learned in law school to date? Other than the fact that you don't know Morgan Maker.
Yeah, that's a pretty memorable thing. I don't know. That's a good question. I really liked my legislation and regulation class. Everything there, I had zero previous knowledge. So I guess that was all interesting. I'm not, hopefully memorable. Hopefully I remember that.
So, Judge, that was kind of an epiphany for me. Apparently at SMU,
I
that's
just
actually a
realized
first.
our YouTube is still on, isn't it? I think. Shoot. Let me turn off YouTube.